what would you say are the biggest pros and cons of doing surrogacy in Florida?
And I actually should take an even bigger step back and mention that what we're talking about today is gestational surrogacy. So this is where the surrogate does not have any genetic connection to the child, which I presume is the only situation where Fairfax would be handling anyway. But in Florida, both are legal. I really only handle gestational surrogacy. So this is again where the surrogate is not genetically related to the child. And the pros in Florida, as I was saying, is we have a legal framework for any parent that wants to become a parent via surrogacy. So it's a very established law, a clear process. And so the parents can go into this comfortably knowing that they'll be a legal parent at the end of the day. Whether it's a pro or a con, what's unique to Florida, our surrogacy statute does have a medical need requirement. It really is a best practice per the American Society for Reproductive Medicine that anyone proceeding with surrogacy is doing so based upon some type of medical need, but that's actually codified within our law. So in Florida, you have to proceed with surrogacy based upon a situation of where the intended mother has difficult gestating a pregnancy to term, or there's a risk of pregnancy to the mother or the fetus. Some might see that as a con, but because it might make a parent wonder, do I meet this requirement of the Florida law? I see it as a pro. I think that it really makes people consider why they're doing it. They collaborate with the doctors to make sure there's a medical need. So whether it's a good or bad, just mentioning that's a specific thing to Florida law. I think it's a pro that our surrogacy statute does require a written agreement entered into between the parties. I think that really protects everybody involved, the parents, the surrogate. So it's a very clear framework of who the parent will be, what the payments are going to be. And so that I think is important. Florida law does not require two separate lawyers for the parties, but it's absolutely a best practice and one that I always maintain for surrogacy, that the surrogate be separately represented by her own attorney, paid for by the parents. Again, not required by law, but just an important thing. So I guess for cons, since it can't all be pros, I would say in Florida, people are nervous about our abortion laws, and that can be an entire different conversation, but we do have very restrictive laws regarding a permissible abortion. It's essentially a 6-week ban in Florida, with very limited exceptions to allow it past 6 weeks, which makes people nervous, understandably so. There's nothing in our law that prevents the parties from agreeing to travel outside of Florida if that was needed. And at this time, absent any changes in the laws, that is how we address it in Florida. So that kind of turns into a pro that there's nothing that prevents the parties from having to agree to a state to go to where the parents would pay for the travel and the medical expenses and everything. If an abortion was needed or a selective reduction, that the surrogate would likely have to do it outside of Florida. So I think whether it's a pro or a con, I think it's just a really important matching point to think about. Something that Fairfax will talk to everybody about when they're being matched. Just, is the surrogate okay, not just with having an abortion if the parents ask, but would she be okay to travel outside of Florida? Because that likely will be needed at this time, given our current laws.